go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom, whether or not there were any other matters that were discussed along with that. I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Cappleman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know. I'm going to go over to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony. So, hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Yes, sir.
Please make your argument.
Judge, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zelman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as to the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge,
Why should this witness be permitted to testify, Mr. Zelman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Cappleman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
As to your point of the state getting a fair trial, Ms. Cappleman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
reviewing Earhart, exclusion of the witness, court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Proffer can be taken on this matter. After that, I will step down, briefly review what I need, and make a ruling. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc. in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then Other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts, and I have known Kristen for 40 years. We went to law school together, and I know how she practices. I practice against her often, so I had some ideas about the lack of strength of Mr. Markel's motions, and she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Cappleman, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes. Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.